the International Conference on Agriculture and Forestry.
Today I'm going to talk about an issue in the United States about compensating farmers for damages from neighbors' pesticide spray drift. And I think I have some pictures here in just a minute to show you. But what we're looking at is property rights. Who has property rights in what? And it's partly fairness also. If one farmer is spraying a crop and it goes on the other farmer's crop and ruins the crop, what should happen? And so every society has a system to resolve this, and I'm going to talk about how it's resolved in the United States. So what are pesticides? I think all of you are familiar with pesticides. We've talked about them in earlier presentations. They're used to kill harmful organisms like insects, weeds, and plant pathogens. But they do present problems and dangers to the environment, including other insect species that we actually like. And certainly don't want to harm things that the pesticides aren't supposed to be harming. Spray drift occurs when pesticides are applied and the wind or the air takes the pesticides and spread them to neighboring property. So it's when the air carries pesticides to non-target property. We put pesticides on target crops to kill pests, but if they go on other property, other crops, then that is not fair. And under American jurisprudence, we have liability for damages from the application of pesticides where it drifts on non-target properties. So there are different possibilities on who should bear the losses from this pesticide drift. We could say the applicator is always liable for it. We could say the poor recipient, that's their problem. They shouldn't have land near the pesticide's use. Or we could have a third party or use insurance to cover the damages. So the law often assigns pesticide drift to applicators, and that's what American law does. And the law may not assign liability for pesticide drift, so if this is the case, then there's no remedy, and if there's no remedy, then the neighbors are injured unfairly. So they also may be covered by an insurance policy, as I have mentioned. So in the United States, private property rights recognize the right of property owners to not have spray drift come on their property. So under this doctrine, we consider the fair use of property to include the needs of the neighboring property and harm to pesticide-sensitive persons. So there's two aspects here, the human and property. Here we see some damages from spray drift on corn. Here's some damages from pesticides on soybeans. And here we have cotton where we have pesticide damages. Pesticides can also harm people. We aren't supposed to apply pesticides when people are in the field picking crops, but sometimes this rule is broken and there's damages there. And other applicators might not use proper equipment and may suffer damages. In the United States, spray drift liability depends on state law. We have a federal law governing pesticides, but liability is under state law. And there are three major doctrines that are used in the United States. There's trespass, there's negligence, and there's nuisance. And so we're first going to spend most of our time looking at trespass because this is the best cause of action if you're injured, if you can prove it. Of course, if you can't prove it, then there's a problem and you have to use one of the other causes of action. Trespass may occur from spray drift carried by the wind, or pesticides are known to volatilize after they've been applied. So you apply them to the plant, there's no wind, they're sitting on the plant, the wind comes up and it actually carries pesticide from those plants to neighboring crops. This can happen for some pesticides. And then there are cases of soil particles being carried by wind that had atrazine in them. That's a herbicide to kill weeds, and the wind carried so much atrazine-laden soil that it damaged a neighboring crop. Three major trespass issues under American state jurisprudence is, does drift or volatilization interfere with exclusive possession? To have a trespass, you have to have an interference with exclusive possession, and some states don't feel that an intangible object like spray drift does this. Next is a tangible physical invasion required, and third are actual and substantial damages required. So 2 recent cases show the controversies here in the United States. Under state law, we have different results. We're going to look at a Colorado case, and we're going to look at a Minnesota case. In the Colorado case, this is a lawsuit. We found that spray drift was a trespass. In the Minnesota lawsuit, we found that there was no trespass, even though the spray drift had entered the neighboring property. So let's look at the Colorado case first. We had organic producers suing neighbors for trespass and a nuisance, and one of the plaintiffs was also a registered pesticide-sensitive person. A few states have special laws for people that are very sensitive to pesticides. These people register with the government. The government tells the neighbors, and before the neighbors spray, they have to notify this person that they're going to spray so the sensitive person can stay away or whatever. And this is what happened in this case. Here was an insecticide being applied next door. The husband was applying it because his wife had had West Nile virus, and they wanted to kill all the mosquitoes so she wouldn't get this disease again. So they said, well, we'll get rid of all the mosquitoes, we'll spray everything. And so that's what they did. They sprayed everything. And it went on the neighbor's property. Not a good situation because the neighbor was raising organic crops and they had a sensitive person there. And so they were very upset, and they brought this lawsuit against the applicator for trespass. It was discovered that the defendant husband, the applicator applying the pesticide, had no license to apply the insecticide, and he had also not calibrated the London fogger, the machine that he was using. So this guy was doing a bad job, right? A bad applicator. We don't feel sorry for him. So we're real happy that he got sued and he's going to be liable for the problem. And the court said there was intentional entry of the malathion to the property, and there was no evidence showing that the malathion had not come from this person, so he was going to be liable. There was a physical invasion because they could feel and see the spray, which not all courts agree on that, but this Colorado court said this is a physical invasion. And so the plaintiffs were granted summary judgment, which means they won without going to trial. They didn't even have to go to trial. Their evidence was so strong that there's no way they're going to lose. So the court said, plaintiffs, you win. The applicator did a bad job. And they also got an injunction to prevent this man from applying pesticides in the future. So the significance to agriculture is trespass actions in Colorado are possible, and governments can have laws on sensitive persons, so you need to realize that. Applicators should have licenses if required, and in this case a license was required, and applicators may be required to have records about the calibration of equipment to show that they're using nozzles that are calibrated to spray the right amount. So there's a lot of requirements here, and if you're using pesticides, we feel you should meet these requirements because pesticides are very dangerous and can cause damages. So that's Colorado. Moving up north to Minnesota, we have another case, similar facts, different result. In this case, we had a cooperative, an agricultural cooperative is using herbicides, and these herbicides drifted onto neighboring property that was growing organic crops. And the plaintiffs, the organic growers, reported that the pesticides had come on their property, and the certification agent, for organic crops we have certification agents, the agents wrongfully told the farmer you can't sell your crop as organic. And so they didn't, and of course they lost a lot of money because they couldn't sell our organic crop. And so they sued the cooperative, claiming damages under trespass as well as nuisance and negligence. So here we have a herbicide being sprayed, and it may just drift on property. And here we can see visual damages to soybeans. The leaves are curling and misshapen, and this is what happened in this case. Under Minnesota law, intangible objects entering property on another do not create a trespass. So the difference is between a tangible physical object and an intangible like spray drift or noise or sound or something like that. And in Minnesota, the court felt that spray drift was intangible. Even though sometimes you may feel it and sometimes you may see it, they said it's still intangible, there's no trespass. So under federal law governing organic production, the court said that the products could still be sold as organic. Wow, this is really shocking to the organic producers in the United States, because we always thought that any pesticides is not okay. Well, there's a 5% minimum. If you only have up to 5%, it is allowed if you didn't do it. If you're the grower, you can't put any pesticides on, but if you're the grower and your neighbor causes 4% to come on your property, that's okay. You can still sell it as organic, according to this court. So very interesting result on organic products. So there was no evidence that the plaintiff's products exceeded the tolerance level. If there's no evidence of breaking the tolerance level, there's no damages. They could have sold their crop as organic. Unfortunately for the farmer, their certifying agent told them wrong information. So they need to sue the certifying agent, right? Defendants may incur liability under nuisance law and may be willing or may be able to get injunctive relief under something other than trespass. So the summary for trespass in these cases show that we have different opinions on what is a trespass under American law. And so it depends on what state you live in if it applies. Historic trespass principles may not provide good resolutions for damages from trespasses by intangible objects. We've seen this in a number of different states where intangible objects, electromagnetic fields, noise, and things like that, there's no trespass. Given advances in science and technology, we may actually need to change our law, and some states have, but some haven't. Negligence is the second cause of action. The problem with negligence, it's very difficult to prove. How do you prove which farmer caused the damages? And so it's unusual to win a negligence lawsuit. The same with nuisance. You have to prove that there's nonconformity with community practices. If everybody's a farmer, is there really a nuisance? There may not be a nuisance. So this is difficult to prove also. So observations concerning liability, pesticide drift damages do cause problems, and generally the applicators are liable, and they're actually usually in the best position to incur liability. They're the ones doing the action, so if they do the action wrong, they should be liable. Persons damaged by pesticide drift generally have not done anything wrong, and so they should be able to collect damages if they are injured. But governments continue to have a difficult time regulating spray drift. In conclusion, I would say that agricultural producers have duties to neighboring property owners, but there's no single answer under American jurisprudence as to whether damages from spray drift will be recognized as a trespass. Negligence and nuisance are very difficult to prove, so that might not be very good for the injured person either. And persons suffering damages from spray drift generally in some states have a very difficult time in proving their case and collecting damages. That's the end of my conclusion. I certainly thank you for your listening.